Hi everyone, I'm Madelena Viksne. I'm a senior associate at Samfiru Tumarkin working in the Employment and Labor Group. And I'm here to answer some of your questions today. But I thought I would start off sort of speaking about workplace relationships since they are back in the news again. There's been a couple recent scandals, I guess. One of which is these YouTube creators, Try Guys, who have cut one of their four founding members um, out of the company for what is allegedly a consensual adult workplace relationship. Um, there are a number of sort of considerations that you want to have in regards to any workplace romances. Um, for employees, be careful, especially if there is any sort of a power dynamic or power difference, perceived or real, between you and the partner. It's very important that you understand that the more subordinate somebody may be to you, the more likely it is that there could be a problem raised with the relationship. Um, you also want to protect your workplace. A fallout in a workplace can be humiliating, could damage your reputation within your community or your workplace. Um, and it's generally not a good idea to date an employee in the workplace who is someone you manage or provide instructions to. Um, you should also make sure you're aware of any employer policies that you have with regards to dating in the workplace, or real or perceived conflicts of interest. These are especially common in the contracts that you might have as a manager um, in a workplace. They sometimes add in extra provisions when you get promoted to management, and often there is language about favoritism, workplace relationships, conflict of interests, and it doesn't necessarily matter whether or not there is a real conflict, because the perception of a conflict or favoritism can be sufficient to cause a problem. It's always a good idea to consult HR if you're not sure about these policies and whether what you're doing is acceptable. And if the policy does require that you disclose your relationship, make sure that you follow the procedures and processes before it becomes any kind of a problem. You don't want rumors swirling and then you go to HR. It's definitely better to disclose earlier. And even if your workplace doesn't have any policies that deal with workplace dating or conflicts of interest, um, you may want to consider confidentially disclosing the relationship so that you have some control over how that is managed. For employers, don't turn a blind eye to workplace relationships. Consider hiring an employment lawyer to draft some form of a policy that deals with the realities of workplace relationships. Um, it is important, however, to remember that like a total ban on workplace relationships in this day and age is quite archaic. But you can put into place sort of safeguards to prevent relationships between superiors and subordinates, and real potential or perceived conflicts of interest. Um, any policy that is put in place should outline procedures for reporting the relationships on a confidential basis and outline measures that could be implemented if there's a breach. Um, Having a full-on ban on workplace romance is likely to have the effect of losing some long-term and good employees, and it'll cost you in the long run. So the same way that employees want to weigh sort of the risks and the pros and cons of entering a workplace relationship based, for reputation and so on, you should also assess pushing employees out by prohibiting things like that. Revise, update, and review discrimination and harassment policies. Always investigate claims of sexual harassment, um, and never jump the gun on terminating an employee just because they're in a workplace relationship. It certainly is something that would require some nuanced investigation and further communication. And make sure that your enforcement measures are carried out equally and consistently with all employees. So you as the employer also should be careful about favoritism or the perception of that. Um, I have a question from P. Chan on YouTube. The employees' survey was bad. The president of the company reached out to the individuals to inquire why. After speaking up, I was later given a warning letter stating I'm rude when interacting with employees. I asked several times for evidence of it, but none was given by employee relations. I've since moved from exceptional annual, I'm guessing, ratings. Sorry, I'm not sure what that says there. You've been working here for 15 years. Do I have any recourse? Um, I'm not really sure if your question is if what you mean is you were evaluated by the employees. They provided surveys to the president about you, and the feedback was negative, or if you were asked about your own survey, told the president what you thought, and then began to experience differential treatment or poor treatment, and receive poor reviews. If it's the latter, then I would say that there is potentially a possibility that you would be able to frame it as reprisal action depending on exactly what's happening. If your bonus, for example, is um, tied to the reviews that you received and you weren't given any chance to respond to them, you haven't been given any time to remedy the behavior, um, or your comments that you did make to the president sort of float around, somehow interact with your human rights or employment rights, and you were sort of working to enforce those. Um, in making those comments, then it's possible you have potentially some reprisal action happening. But as I said, it's difficult for me to say from this which sort of side, how the timeline goes. Um, Question from Facebook from Shanna. Can my employer change me to night shifts? I've been working days for 2 years and have children. Um, it's going to depend partly on terms in your contract. So there may be terms that set out what your regular hours are. Alternatively, there could be terms that say that can be moved around to shifts as long as you're getting X number of hours per day. If you were hired onto the night shift and that's the only shift you've ever worked and it's the shift you agreed to work when you were hired, you probably have a stronger argument for that being the shift that is yours. Um, that being said, 2 years is a long time. If you need the shift to stay the same because of children, you could ask for accommodation pursuant to family status. Um, if you're having difficulties with childcare or anything like that because of the night shift schedule, um, and your accommodation that you would request would be to remain on the same schedule as you're already on the basis of childcare needs and so on. Um, it really would depend on sort of partly the terms of your contract, but generally speaking, the employer can't just, you never worked a Saturday for 15 years and now you work 15 hours on every Saturday. Without your consent, they can't usually make significant scheduling changes like that. It's also going to depend partly on whether this is going to change your hours or your earnings. So it may be worthwhile to give our office a call if you are having issues. But I would say the first step would be to um, in writing, request accommodation from your employer um, on the basis of your family status and discuss the fact that you have children and you can't work these night shifts because of childcare needs or whatever the reason is, but circling back to the children. um, JBK from YouTube says I was denied EI benefits from November to April because I wasn't vaccinated. I was called back to work in April. Is EI back paying since COVID restrictions were lifted? Not that I'm aware of. The reason that you would have been denied would have been the code that was put on your ROE by your employer under the direction of the government. I have had a number of clients who've appealed it, and some have been successful, and some have not appealed the denial. Some have had to go through the entire process and still not gotten any, and some have actually just received them depending on what code was there, or at an earlier stage in the process. If you were to be, approved for the benefits, then yes, you would get back benefits. They do backdate them, but if it's a vaccination case, it seems to be very hit or miss in terms of whether even appealing a denial will be successful or if it will just be another headache for you. Um, Julia from YouTube said, when is an employer allowed to not pay an annual salary bonus? I work in sales and thought it was part of my annual salary. Um, if it's salary and bonus are two separate things. So if it's salary or commission based earnings, those are wages, and your bonus would very likely be separate from that. It's going to really depend on what the language in your actual contract says. Um, if it is lumped into the compensation section, for instance, you could make the argument that it is part of your compensation. If you receive the same amount every single year, that's another way that it can be, brought into your overall comp. If you've received it consistently for a number of years, that's all helpful for you in terms of framing it as part of your expected compensation. If the language in the bonus is clear and unequivocal that the bonus is discretionary, it's not based on things like hitting targets or specific metrics. It's just based on sort of what they want to do. In those cases, you're going to have a difficult time demonstrating that it is part of your expected annual compensation unless you've been there and have some sort of a track record that shows that you have, relatively consistently at least received the bonus. And likely what will happen is it'll be an average of 3 to 5 years in the event that you were challenging that. RBR says, I recently turned down a promotion along with another coworker that I was previously managing. Now he's managing me, and I feel that my workload and responsibilities have lightened considerably. I'm concerned that I'm being targeted now by my boss. If I get let go, is that retaliation? My reason for turning down the promotion was health related, as well as health issues with a mother who has dementia and lung cancer. I just felt like I can't take on the extra stress at this time. So I think, and you can correct me if I'm wrong, I think you're saying that you turned down a promotion, your coworker accepted the promotion and is now your manager. And you feel that he has been stripping down your work duties, or you just feel like you have less to do because something else. I guess that's what I need to kind of determine here. The reason for turning down the promotion is that's your personal business. That said, obviously they needed somebody in that position, so there's not really any issue with them having given that promotion to somebody else. Depending on what you mean by you feel you're being targeted, I'm not sure if you mean he's stripping away your duties or if you mean you're experiencing bullying and harassment, something like that. Depending on what you mean there, depending on what you mean there, it would sort of change the answer in terms of whether or not it is possibly retaliatory if you are terminated. It would actually be more likely considered reprisal. But you need to address these issues with your employer in writing first. So my suggestion would be to identify what you see as, the issues since this promotion and that you're discussing here. So being targeted, having your duties lightened, and so on. In some detail. I mean, don't write a novel, but make it clear that you're talking about specific incidents or specific things. And then tell them that you don't agree with the changes to your employment. You don't agree with the changes to your work duties and responsibilities. And you're concerned about the conduct of your new manager. And that you want to have it on the record that you're not agreeing to these changes. once you've done that, then, reprisal might be easier for you to establish because you've demonstrated that you've told them that you don't agree, alerted them to the problem, and if nothing happens to fix it, that's one thing, and if they fix it by terminating you, that's another thing, but it's a termination based on you attempting to enforce your rights under the Employment Standards Act or otherwise. So that's my suggestion for you. Question from on Facebook from Anthony. What is the best way to deal with harassment in the workplace? Well, you shouldn't have to deal with it, first and foremost. All employers are covered by the occupational health and safety legislation, which requires that they ensure the workplace is free from harassment and bullying and violence. So if any of that is going on, there's a problem. The first thing you should be doing is, first of all, it kind of depends on what you mean by harassment. So obviously, we all know what it's like to be harassed or treated poorly. But in the workplace and under the legislation, the legal threshold for what kind of conduct would establish that harassment in the workplace is taking place, is higher often. So, your boss kind of being rude to you is likely not enough, but if he's yelling slurs at you every day, it's pretty clear that would hit the level. So it's very, very fact specific in terms of whether or not the threshold for legal harassment has actually been hit by the conduct. In the event that it's not very overt, or it's like more subtle things, I usually suggest that my clients try to interact with that person only in writing as much as possible, and also that they email themselves like little entries when something happens. The reason for that is that your emails are timestamped. So it's great to keep contemporaneous notes, but if you write them by hand, we can't really prove that they're contemporaneous. If you're sending yourself emails and using that sort of as a journal, then it's very clear, like the dates are there. We know that it happened on you emailed it on the same day. It's not something that you could have fabricated and made up later. So that's a really good way to keep a record of some kind. I don't suggest recording in the workplace. There are a number of different issues with that. I've spoken about it before on the live. There's a lot of privacy concerns in relation to that. There's also a case where somebody surreptitiously recording a bunch of people in the workplace to an excessive level. It was found to be cause for termination. So I would not suggest recording anybody. I generally just say to email yourself or write your own notes about what's going on. If it's reached a point where you think that it's no longer tolerable, and whether or not you've tried to address it with that person, usually that would be the next step. But if you're not comfortable doing that, you can report it to HR or to your manager, whoever you're supposed to, based on sort of your company's hierarchy of the reporting structure. And they should conduct an investigation depending on the seriousness of the allegations and what sort of comes out of their initial conversations with you. When they're doing an investigation, you should be kept up to date about sort of the status of things. If you give a statement and then the person you accused also gives a statement, you should also have a chance to reply to whatever it is that they say. Whoever is the one doing the harassing or accused of doing the harassing should be removed from the workplace, or at least kept away from you. And the whole thing should remain as confidential as possible to the extent that it's able to be. Obviously, if they're doing investigations, they're going to have to interview people, so word will get out, but it shouldn't be something where you go and report something and suddenly the whole office knows. It should be kept quite confidential. So keeping a record, reporting it, ensuring that an investigation is happening. If an investigation isn't happening, escalating that process through the company itself. through their harassment policies and procedures. And also, you can escalate it outside of the company within the Human Rights Tribunal or Ministry of Labor, depending on what the situation is. Also, speak to a lawyer. Always speak to a lawyer if you. I generally say that if you have an incident other than something like a missed payment or um, vacation issues or something like that, if you have a serious incident that you feel you need to report to HR, it's probably time to speak to a lawyer. HR is the shield basically for the company. They work for the company and their interests are generally aligned with the company. There's great HR professionals out there, not denigrating them. But I do think that it's important that you remember that they are not there for you. They're there to be sort of a step in between and help prevent liabilities and litigation for the company in part. Um, so if you feel like you need to report something to them, it's probably a good idea to get a lawyer's advice about your specific incidents, either before or after, but I would probably say before. Danny from Facebook has asked, my employer is not properly paying out for our hours worked. What can we do about this? Um, I'm not sure if you mean just for you or across the company. Either way, the best and probably quickest way to manage that would be to make sure you have records of the hours worked and get all your pay stubs and make a Ministry of Labor complaint. They will investigate it, they will adjudicate it, and they will order payment. If you can't be reprised against by your employer, so punished in any way for bringing a Ministry of Labor complaint. I mean, obviously, my first suggestion would be to go to the company and find out what's going on, if there's some reason for that, or if you're, maybe confused about the way hours worked. It's important to remember that you have unpaid meal times likely in your day. So a 40-hour week, you'll actually only be paid for 37.5. But if you work anything over, depending on the province, 40 or 44 hours, you should be being paid time and a half for that time. So make sure that that's happening. Gather all of your pay stubs and records and everything and make a complaint to the Ministry of Labor. They have a really helpful like legal help call line for employees. And it's a pretty streamlined process. And if you make a complaint like that and then you're fired, that's reprisal action and it just makes things worse for the employer. So it does protect you in that way. Lauren from Facebook said, my employer laid me off in May because I need a workplace accommodation for an injury. They said they can't accommodate it this time. Is there anything else I can do? Have you filed a complaint with WSIB or WorkSafe, depending on what province you're in? If you haven't, you should certainly do that. If your employer has short-term or long-term disability coverage, you should also explore that. HR should be able to provide you with those documentation, or you can call your insurance provider. EI sick benefits are maybe another option, which would be 16 weeks of pay. But you would need them to issue you a record of employment saying that you are laid off for illness or injury. If they are not able to accommodate your workplace injury at this time, it's important that you are continuing to provide them with updates. You're not laid off, you're on a medical leave, most likely. You should check what your ROE says. But it's most likely that, the most important thing is for you to continue to update them with respect to your medical status as soon as anything changes, or every couple of months, provide them with a new doctor's note. They should also be following up with you about that as well. They should also be exploring other positions and alternative sort of work that you could do within the company, even if it's outside of your normal scope. That would be suited to your accommodation. So, for instance, if you used to be a tow truck driver and now you can't drive for whatever period of time due to an injury, there's no reason that if a position working on a computer or doing the call center came up, that they couldn't put you on that for a temporary period because it doesn't involve the same sort of physicalities, um, and would be a way to get you back to work in some capacity. You should speak to your doctor about a graduated return to work plan whenever it sort of starts to become something that you're going to be exploring. And your employer has a procedural and substantive duty to accommodate you. So not only do they have to, consider what your restrictions are, like ask about them. Their duty to inquire is triggered by your injury. Their duty to accommodate you to the point of undue hardship is also triggered. So as long as you are participating in that process, they should be interacting with you and working with you to find alternative options for you while you're recovering that would allow you to get back to work within the scope of the restrictions that your doctors have provided. They may ask you for a functional abilities form. That's fine. You can get that filled out by your doctor. Um, and If it was a workplace injury, WSIB or WorkSafe would be a really good resource for you. You should definitely explore it. Um, in the event, like the example I just gave with the tow truck and doing the call center, often there might be a change in wages. If there is a change in wages for the accommodated position and it's a WSIB or WorkSafe file, WSIB or WorkSafe will generally top you up, at least, or they have the option to order that you're topped up to what your regular wages were. Um, they also have the ability to send you for additional training if the workplace injury is never going to reconcile, or you'll always have some sort of permanent restriction. Um, if your employer is engaging you in the accommodation process and having discussions with you and asking you for updates, you're likely on a medical leave because there isn't anything available. Another thing to do is check Indeed. Be watching things like Indeed to see if your employer is posting positions that should have been canvassed with you. Um, but if you've explored all of these things already, and you're ready and able to return to work, and your restrictions are within the realm of possibility for your employer, or you believe they would be, it would probably be a good idea to call our office and speak to one of our lawyers about the situation in more detail. What your role is. You don't have to say it here, but what your role is, what the injury is, what your restrictions are, whether it might actually be possible, and then what your next steps would be. Okay, so uh, P. Chan from YouTube from the very beginning has rephrased his question. The employees were given a survey for the department. The surveys were negative. They were evaluating the department, process, management, treatment towards employees, etc. The president wasn't happy with the results and wanted to speak to the employees. You spoke to him frankly and honestly about why the issues you saw in the department, and you feel that immediately after speaking up about it, even though you were asked to provide that feedback, your manager started finding issues with you, and causing you problems at work. Um, you've asked for evidence of what you did, but they won't give you any. So I'm not really sure why you would need the evidence for what you did. You've been told what happened. You have a theory that it has to do with those survey results. Unless they're accusing you of being rude to customers or employees in a specific instance, there may not be like evidence for them to provide. It's likely that it's more so based on like their observations or someone else's report, if it's even true. But if you feel like you're being targeted by your manager, um, I would do all of the things that I had said just a little bit earlier in terms of dealing with harassment in the workplace. Um, keeping contemporaneous notes if you feel like it's very targeted on you and you're having difficulties. It could be time to speak to a lawyer or to HR. You've said that you've now become mentally ill because of this. um, if your employer has short-term disability or long-term disability coverage, or if you feel like it's based on harassment, your mental distress is based on the harassment in the workplace, you may have a WSIB claim for mental distress. You may have a work safe claim if you're in BC. Um, it would be a difficult one to establish as a constructive termination, depending on the very specific facts of your case. So, if you are thinking about exploring that, you would have to call our office and provide us with a lot more detail about what's going on. JX2, you're going to be my last answer. Company that I work for has eliminated my position, has offered me other work. The holding company has other businesses. How can I maintain future severance rights if I were to move to a different company under the same holding company or group? Sign a new contract that says that it is going to, that even though you're working under the new company, they are going to respect your seniority and the full 10 years starting at whatever your actual start date was um, under this new contract. And that you, for the purposes of things like termination, vacation, um, termination, vacation entitlement, um, things like that. So you would want it to say it. It usually says it in one of the first two paragraphs of a new contract, that that your seniority is continued or that your tenure is continuous, that they're adopting or taking on your seniority, respecting the original start date of X for your continued employment under the new company name. That being said, if they are providing you with a contract at this stage during your employment, I would not sign anything until you've had a lawyer look at it. You actually don't need to sign contracts once you've already been working. So because and oftentimes they will limit your rights going forward. It certainly is an important thing to do if you're offered a new contract, a new policy, any of that stuff, to have one of the lawyers in our office take a look at it. It's worth the money, I promise, because there's many times where it's much easier for us to fix it ahead of time, um, before there's a problem, than it is for us to deal with a contract that was signed 10 years ago and wasn't negotiated and has a term that's problematic for our client. Okay, well, that's everything for me today, guys. The next live stream presenter will be Lior Samfiru on Wednesday, October 12th at 1 p.m. Eastern Time. And until then, anyone that I wasn't able to answer, I apologize, but Lior will be around to answer your questions tomorrow. Okay, thanks so much.